The Supreme Court just detonated a legal bomb in the middle of American gun law, and the shockwave hasn't stopped traveling. A 9-0 ruling, unanimous, no partisan fingerprints, no partisan escape hatch, just dismantled the legal architecture that has governed firearm ownership in this country for over 100 years, not tweaked it, not revised it around the edges, dismantled it. The Supreme Court's 9-0 gun ruling is the story that every American needs to understand right now. Because what just happened in Washington is going to change the laws in your state, in your city, or in your street, whether the people in power want to tell you about it or not. The panic you are hearing about in Sacramento, Albany, Springfield, and Trenton is not theater. It is not hyperbole manufactured for cable news. It is a legal emergency that every attorney general in a restrictive state woke up to this week staring at the ceiling about at 2 in the morning. Something just changed, something fundamental. And the question I want you sitting with right now is whether that change makes you safer or whether it makes the person walking behind you more dangerous. That is the real question, not the political one. Before we go any deeper, if you want to stay ahead of what is happening in the lower courts right now, because rulings are dropping faster than most newsrooms can track them, hit that subscribe button right now. We are covering every single development as it lands, in plain language, without spin. Now let's get into it. Let's start with the piece that has the most immediate impact on the most people, because this is the one that states like New York and New Jersey built their entire gun control architecture around. It is called the May issue permitting system, and for decades it was the most powerful tool local governments had to control who was and wasn't allowed to carry a firearm in public. And the way it worked was not complicated. It was, in fact, deliberately simple, in the way that all systems designed to keep certain people powerless are deliberately simple. You could pass your background check. You could be a law-abiding citizen with a clean record and a stable life. You could take every required course, fill out every required form, and hand over every required document. And then a police chief or a judge or a local official with near total discretion could look at your application, decide that you had not demonstrated what the law called proper cause, a specific, articulable need to defend yourself beyond the general desire not to be murdered, and deny you, full stop, no appeal that mattered, no recourse that worked, just denied. Think about what that actually means in practice. Think about who that system was designed to affect, because it was never applied equally. Wealthy people in restrictive states hired lawyers and made connections and navigated. That process, connected people got their permits. Judges knew other judges. Police commissioners knew business owners. The system worked fine if you had access to the right rooms. But if you were working class, if you were a minority in a neighborhood where crime was real and police response times were long, if you didn't have $5,000 to spend on legal fees just to exercise a constitutional right, that system was a wall, a very deliberately constructed wall. And behind that wall, a lot of people were left defenseless while the people who built the wall went home to their security systems in their gated communities and slept just fine. Ago in the Bruin decision. But here's the thing about power, it does not surrender quietly. States like New York did not simply comply. They rewrote their laws. They invented new categories of sensitive places. They created new layers of bureaucratic requirements. They looked at the Bruin ruling and essentially said, fine, we'll just call it something different. And for 2 years, gun owners in those states lived in a whiplash of conflicting court decisions, where a law was constitutional one week and unconstitutional the next, depending on which judge you drew. That legal chaos ends. Now, this 9-0 ruling is not a suggestion. It is not an invitation to get creative. It is a hammer. It says with the full weight of a unanimous court that if you are not a prohibited person, if you have not committed a crime that removes your rights, the state cannot invent a bureaucratic reason to keep you disarmed. The era of subjective discretion in the permitting process is over, not fading. But the May issue system was only one pillar of the structure that just collapsed. 3 more went with it. And they are the ones that reveal something deeply uncomfortable about how we have been framing this debate. Because the mandatory training requirement, the waiting period, and the application fee were always sold to the public as common sense safeguards. They were sold as reasonable. They were sold as the kind of middle ground compromise that reasonable people could support. And some of those arguments had genuine emotional logic behind them. Who could object to training? Who could object to making sure someone knows how to safely handle a weapon before they carry it in public? The answer as the Supreme Court just made clear, is that the objection is not to training itself, it is to the government. Using training as a mechanism of exclusion, here is the distinction the court drew, and it is one that matters enormously. The court did not say, training is bad. The justices openly acknowledged that firearms training is valuable, that it saves lives, that a trained carrier is safer than an untrained one. What the court said is that the government cannot weaponize training requirements as a financial and logistical barrier to entry for a constitutional right. And if you look honestly at how those requirements worked in practice, the court's point is undeniable. In some states, the required course cost upward of $500. It was offered twice a year at locations that were hours away from the communities where people most needed to be able to defend themselves. You had to take time off work. You had to arrange childcare. You had to pay fees you couldn't afford for a course you couldn't get to. Just to apply for a permit, you might still be denied. That is not a safety measure. That is a poll tax. That is the government charging you for the privilege of exercising a right that the Constitution says the government cannot burden. The court called it exactly what it was, and those laws are gone. The waiting period is the one that produces the most visceral disagreement, and I understand why. And the logic behind it was always emotionally compelling. And the cooling off period idea, the notion that if someone is in the grip of a rage-fueled crisis and walks into a gun store, a 3-day or 10-day wait might break the emotional momentum and prevent a tragedy. That is not an irrational idea. It is, in fact, a humane idea. The problem is that the court just ruled that it is an unconstitutional one. By 9-0, the justices decided that delaying the transfer of a lawfully purchased firearm to a law-abiding citizen imposes a burden that the government cannot justify under the new constitutional standard, and the fee structure, the $200 application fee, the $100 fingerprinting charge, the layered costs that turn the permitting process into a revenue stream for state bureaucracies, all of it goes with it. The court standard is now that fees must be nominal. If the cost of exercising a right is prohibitive for a working-class American, that cost is unconstitutional. 3 pillars down, and then there is the sensitive places doctrine, where states after the Bruin decision tried something audacious. They attempted to designate virtually every square inch of public space as a sensitive place where carry was prohibited, not courthouses, not schools, every parking lot, every public transit platform, every convenience store, every place where ordinary people move through ordinary life. The court looked at the historical record and said that is not what sensitive places means and has never meant. Sensitive places historically were legislative chambers and courthouses. They were not the subway platform where a woman is waiting alone at midnight. Those blanket prohibitions are gone too. To understand how this happened, how the court arrived at a unanimous 9-0 decision that strikes down a century of gun regulation, you have to understand the legal machinery that made it possible. And it starts with a case called United States versus Rahimi, decided in 2024, which most people remember as the domestic violence case, where the court upheld the prohibition on gun ownership for people under domestic restraining orders. That is what the headline said, but Rahimi did something else, something more consequential, that has been quietly reshaping every gun law case in the lower courts ever since. The Rahimi decision taught lower courts how to properly apply the Bruin test, and in doing so, it created both a tighter framework and a more dangerous one for gun regulations that cannot withstand historical scrutiny. Before Rahimi, lower courts, applying the Bruin framework, were demanding what legal scholars call the historical twin in actual law from 1791, from the founding era, that looked essentially identical to whatever modern regulation was being challenged. If you couldn't find a law from the era of single-shot muskets that looked like a modern magazine capacity restriction or a permit requirement, the modern law fell, and laws were falling constantly at a rate that was producing judicial chaos. Rahimi corrected that. The court said you don't need a historical twin. You need a historical analog, something relevantly similar in principle, even if not identical in detail. That sounds like it should have made gun laws easier to defend. In some narrow cases, it did. But what Rahimi also said is that the government must prove the analog is genuinely relevant, that the historical tradition it points to actually supports the modern restriction, not just superficially resembles it. And that is where the government's arguments fell apart. In this new ruling, the government tried to argue that old bond laws, colonial-era requirements that dangerous individuals post a financial bond before carrying arms in public, justified modern permitting fees. The court rejected that entirely because those bond laws applied specifically to people who had already demonstrated dangerous behavior, not to all citizens exercising a constitutional right. The government argued that 18th century militia training requirements justified modern mandatory training classes. The court rejected that too, because militia training applied to the entire body of eligible men as a collective civic obligation, not as a prerequisite for an individual to exercise an individual right, which is exactly what the Heller decision established. The Second Amendment protects. The government had no analog that held. And without an analog under the Bruen-Rahimi framework, the laws could not stand. What the court applied here, for the first time explicitly to the full scope of carry rights and licensing regimes, is strict scrutiny, the highest constitutional bar that exists. The standard reserved for the most fundamental rights, free speech, voting, now the right to bear arms. To survive strict scrutiny, a law cannot merely be a good idea. It cannot merely be supported by government interest. It has to be proven essential, the least restrictive means available to achieve a compelling government purpose. Almost nothing in the existing permitting architecture could clear that bar. And now it doesn't have to because it no longer exists. Here's where I need you to stop and be honest with yourself. Because this is the part of the story where the ideology has to give way to reality, not the political reality, the human reality, the one that doesn't fit neatly into either side's. Talking points. I want you to picture a specific person. She is a single mother. She works the night shift. She takes public transit home at 2 in the morning in Los Angeles, walking from the bus stop to her apartment through a neighborhood where she has been harassed, followed, and threatened. She wanted to be able to protect herself. She tried to navigate the permitting process. She couldn't afford the fees, couldn't get to the training, and even if she had completed all of it, she was likely to be denied under the old discretionary system because she couldn't demonstrate the kind of specific threat that local officials deemed sufficient. As of last week, if she was carrying a firearm to protect herself on that commute, she was potentially committing a felony. As of this ruling, the laws that made her a criminal for trying to stay alive are likely unenforceable. That is a real person. That is a real consequence. And anyone who dismisses that consequence in the name of gun control is not being honest about who those laws were actually protecting and who they were leaving exposed. Now picture a different person, a state trooper working a rural highway in Illinois at midnight, who pulls over a vehicle for a broken taillight. The driver hands over a permit from a state that, under the new constitutional framework, cannot require meaningful training or extensive background verification. The officer has no way of knowing whether the person sitting in that vehicle has ever held a firearm safely, has ever practiced under stress, has ever been trained in the basic protocols that separate a disciplined carrier from a liability. The officer has to approach that window knowing that the person inside has a legal right to be armed, and knowing almost nothing about whether that person has any idea how to safely exercise that right. That officer's anxiety is legitimate, that risk is real, and anyone who waves it away in the name of constitutional freedom is not being honest about the full weight of what this ruling means on the ground. Both of these people are real. Both of their realities matter. And the reason this conversation is so difficult, the reason it has been so persistently dishonest on both sides, is that neither camp wants to acknowledge the person whose experience challenges their preferred narrative. The honest position is that this ruling expands freedom for the first group and creates genuine complications for the second, and that both things are simultaneously true. That is where we actually are. If you think this ruling is the end of the story, you are not paying attention to how power actually works. The attorneys general of restrictive states did not go home and accept defeat. They went to work. Because here's what they know that most of the commentary is missing. The Supreme Court told them what they cannot do. It did not tell them what they can do. And in that gap, in that open constitutional space, a new legal offensive is already being assembled. The pivot is already underway in states like Hawaii, Maryland, and California. And it is sophisticated, targeted, and designed to accomplish through indirect means what can no longer be accomplished through direct ones. The most immediate front is ammunition. If you cannot restrict the carrier, you regulate what the carrier carries. Microstamping laws, requirements that every bullet fired from a gun leave a microscopic identifying mark traceable to the specific firearm are being fast-tracked in multiple state legislatures. The practical effect is that it becomes vastly more expensive to manufacture and purchase compliant ammunition, pricing many people out of practical exercise of the right. Even if the permit barrier is gone, watch for those bills. They are coming fast. The second front is insurance. Some states are already exploring requirements that any person carrying a firearm in public must maintain liability insurance. The argument being that this is analogous to requiring car insurance for drivers, a regulation of the activity rather than the right itself. The constitutional validity of that argument is genuinely uncertain. It will be litigated. But the chilling effect of requiring someone to purchase insurance before exercising a constitutional right is obvious, and it is deliberate. The third and most aggressive front is the expansion of red flag laws and dangerous person designations. This is the one that should concern everyone, regardless of where you stand on gun rights, because the Rahimi decision gave states a clear constitutional pathway to disarm people deemed dangerous. And states are going to use that pathway, and they are going to define dangerous very broadly. If you have ever had an involuntary psychiatric hold, even briefly, even decades ago, even if you have been stable and healthy ever since, you may find yourself on a list. If you have ever been involved in a contentious divorce where accusations were made, even if they were never substantiated, you may find yourself on a list. The 9-0 ruling removes the permitting wall. The red flag expansion builds a different kind of wall, one targeted at people rather than processes. And it will catch people it was never supposed to catch. Meanwhile, at the local level, cities that cannot pass statewide restrictions are moving towards civil liability ordinances, laws that hold businesses legally responsible for any shooting that occurs on their premises if they allowed firearms inside. San Francisco cannot ban your gun, but it can make every business owner in San Francisco terrified of the financial consequence of allowing armed customers through the door, and the practical effect is the same. The geography of where you can legally carry is about to shrink through market pressure rather than legislation. And the Supreme Court will have a much harder time stopping that. If you are following all of this and you want to make sure you don't miss a single development, this is the moment to subscribe, because the lower court rulings that are about to land in the next 30 to 60 days are going to be the most consequential in the history of the Second Amendment, and we will be here for every single one of them. Let me take you out of the weeds for a moment, because underneath all of the legal mechanics and the political maneuvering, there is a philosophical shift happening in this country that is bigger than any single ruling. And it deserves to be named clearly. For roughly 4 decades, the dominant framework for gun regulation in America was borrowed from public health policy. Guns were treated the way we treat cigarettes or pharmaceutical drugs, as inherently dangerous products that could be regulated into near irrelevance through a combination of taxes, licensing requirements, advertising restrictions, and social stigma. The public health model was intellectually coherent and strategically sophisticated, and it produced a generation of laws that successfully reduced gun ownership and gun carrying in the states that adopted it most aggressively. The Supreme Court just ruled that the public health model cannot coexist with the Second Amendment as written and as originally understood. Not that it is imperfect, not that it needs to be reformed, that it is constitutionally incompatible with the right it was designed to suppress. The implications of that ruling are not merely legal, they are civilizational, in the sense that they force a reckoning with what kind of rights we actually believe in. Because the majority's core argument is one that cuts across issues in ways that should make everyone uncomfortable. Rights, the majority said, are not subject to cost-benefit analysis. You do not weigh the social cost of free speech before you decide whether someone can speak. You do not calculate the aggregate harm of religious practice before you decide whether someone can worship. And you do not measure the statistical correlation between permissive carry laws and urban homicide rates before you decide whether a law-abiding citizen can be armed in public. The right exists. The burden is on the government to justify restricting it, not on the citizen to justify exercising it. That is a profound statement. And the dissenting justices, and there were dissenting opinions, even in the 9-0 decision on the narrow question of permits, made a counter-argument that is equally profound in its honesty. Justice Ketanji Brown Jackson, in a concurrence that read more like a warning than an agreement, noted that the Bruin framework has produced a 455% increase in Second Amendment challenges in the lower courts. She called the system unworkable. She is right that it is chaotic. She is right that the lower courts have been drowning. But the chaos she described is not an argument against the right. It is an argument against the way the right has been administered and litigated for decades. That chaos is the consequence of a century of constitutional evasion finally being called to account. Justice Thomas, characteristically, went further than the majority wanted to go, arguing that the background check system itself should be scrutinized under this new framework. That position may be where the court eventually arrives, or it may not. But the fact that a sitting justice is articulating it on the record tells you everything about the direction of the legal current. What we are watching in real time is the Second Amendment being elevated, genuinely, practically, constitutionally elevated to the same tier as the First Amendment and the Fourth Amendment, not rhetorically, not politically, legally. The right to bear arms now sits on equal footing with the right to speak and the right to be free from unreasonable searches. You cannot require a permit to preach on a street corner. You cannot require a license to publish a newspaper. You cannot require a fee to cast a ballot. And as of this ruling, with the full weight of a unanimous court behind it, you cannot require a permit to carry a weapon that the Constitution explicitly says you have the right to bear. That is the great unwinding, and it is only beginning. What comes next is not a victory lap for one side and a funeral for the other. It is a long, grinding, jurisdiction by jurisdiction, courtroom by courtroom rebuilding of the legal landscape from the ground up. Every state legislature is going back into session. Every city attorney is reviewing local ordinances. Every police chief is rewriting use of force guidelines. Every prosecutor is recalibrating what charges can actually stick. The laws about carrying while intoxicated are going to become dramatically more stringent, and safe storage laws are coming with enforcement mechanisms that have real teeth. Red flag orders are going to be filed at a rate that will strain the court systems processing them. The fight is not over. It has never been more alive. And the central question, whether the expansion of gun rights that this court has now firmly established will produce safer communities or more dangerous ones, is one that neither side can honestly answer yet. The criminologists are genuinely divided. The data from comparable expansions of carry rights in other states is genuinely mixed. Anyone telling you with certainty what the consequences will be is telling you what they want to be true. The honest answer is that we will not know for 3 to 5 years. And in those years, real people like the woman on the midnight bus and the officer on the rural highway, will be living inside the consequences of this decision, while the rest of us argue about it on the internet. What I want to leave you with is this. The Supreme Court has acted unanimously, which means there is no partisan backstory to comfort the losing side. 9 justices, appointed by presidents of both parties, agreed on the core constitutional principle. The permitting wall is down, the fee barrier is down, the training prerequisite is down. The question of whether what replaces those structures serves ordinary Americans better or worse than what existed before is the question that will define the next decade of this debate. And that question deserves honest people willing to hold the full complexity of it, the woman on the bus and the officer on the highway, the constitutional principle and the human cost, and the legal framework and the lived reality without collapsing into a bumper sticker. That is what this story demands. That is what the people affected by it deserve. If this is the kind of journalism you want more of, unsparing, unsponsored, and unwilling to simplify what isn't simple, then subscribe. Share this with someone who needs to hear it. And leave your honest reaction in the comments below. Not your political position, your gut reaction. Because the gap between those two things is exactly where the truth lives. And that is the only place worth looking.